Thank you for joining us today. This next video is going to be somewhat different than my prior videos. I'm going to present it as a training video for those of you who are either trying to probate a will on your own or for attorneys who might be new to the probate practice and would like a little guidance through the probate petition. Of course, the probate petition is just the beginning of a case, but you've got to start somewhere, so let's get started. For those of you who are not attorneys, this is considered the case style. That stays the same throughout a case. You identify the name of the decedent. You identify the court that you're going to be in. And then since you're drafting a petition, you won't yet know the case number and judge, but you will leave a place to put that information when the time comes. Below that, you're going to identify what you're asking the court to do in this particular petition. Let's scroll on down here and start talking about the substance of the petition. I recommend that your opening paragraph would be identify who the petitioner is, the person who's bringing the request to the court. Your first very substantive paragraph will be to identify the person who has passed away, when they passed away, and where they lived at the time of their death. Now, this paragraph number 1 should be identifying where they were officially a resident, because if they were traveling and passed away in another state, the appropriate state for the probate is where they were an official resident. So let me give you another example. If my friend from Godibo is rushed to the Oklahoma City hospital and passes away in Oklahoma City, the district court in the county where Godibo is located is the appropriate place for the probate, not necessarily Oklahoma City. So our next paragraph identifies that the decedent left real and personal property. For those of you who are not attorneys, real estate is lands and houses. Personal property is pretty much everything else except real estate. Bank accounts, your car, your toothbrush, and so forth. This is just a rough draft petition. I think the best thing to do here at the end of paragraph number 2 would be to identify your best estimate of the value of the estate, in part because the state law requires you to do that, and in part because the judge is going to be setting a bond for the personal representative, and in order to know how much bond to set, the judge really needs to know how much money is available, because a bond is very much like insurance against theft. All right, scrolling down. Paragraph 3 is where we typically identify the last will and testament. We identify that we looked for a will, and this is the latest last will and testament. Your client or you are not allowed to choose which will be submitted to probate. You must submit to the court the most recent one. Now, if you are uncertain as to whether the last will and testament that you have in hand is a valid one, maybe you would list both last wills and testaments here and then tell the court what you think should happen. In the next paragraph, tell the court why you are the one who should be filing the petition. For example, if you are the one named as the personal representative under the will, then you have a right to file this petition. Now, you may not be the named personal representative. Instead of personal representative, it may say surviving spouse. It might say only surviving child. It might even say creditor of the estate. Under Oklahoma state law, even creditors are entitled to open a probate. Let's move on to the next page. All right. If you are the one who is applying to be personal representative, you need to identify yourself along with identifying where you live. This is important because if you are not an Oklahoma resident, there will be a necessity that you file yet another document in which you identify an Oklahoma resident as your designated agent. If you don't do that, you're probably not going to have an effective petition for probate. Once you've done that, you need to identify the heirs at law. Now, some attorneys and most people who are not attorneys make the mistake of identifying everybody who is related to the deceased person. This is a mistake. The heirs at law are the people who would receive if the deceased person did not have a will. So you're going to need to look to Title 84, wherein intestate distribution is identified, and the person or persons who would receive, if there were no will, should be named in this area. This is not a list of everyone related to the deceased person. This is only the people who would inherit if that person had no last will and testament. Next, you're going to identify the people who are entitled to receive under the will. These are the devisees and legatees are identified here. So, under the will, Kenneth John Massey Kinnett is the person entitled to receive under the last will and testament that was submitted here. We're asking the court to make a judicial determination that this is the only heir, devotee, and legatee, because we will need that determination if we decide that land must be sold during the pendency of the probate. I would tell you that it's fairly common that we need to sell houses and land during the probate so that we can reduce out-of-pocket expenses and have some certainty when it comes time to distribute the estate. Next, the petitioner should describe how they're interested in the estate, and in this case it was because they were named as personal representative and they are the natural son of the deceased person. This won't always be the terms you use. Sometimes you'll be interested as a creditor or a surviving spouse or some other way. There are plenty of ways that can come into play. But you do need to identify for the court why you're the correct person to be bringing this petition. Scrolling on down, lastly, you're going to identify what you want the court to do. You want the court to set a date for a hearing. You want notice to be given according to law, that the will be admitted to probate, that the court issue letters testamentary to your petitioner, and that the court determine the heirs at law and the devisees and legatees. Please don't lump together the heirs at law, devisees, and legatees. That will become confusing and difficult at some point in the future, or at least possibly will be. Once you've done all of that, the petitioner needs to sign. It is helpful in many cases if they sign this before a notary and under oath, because the court can, it's not required, can accept this as the testimony if it's done under oath and preferably notarized. If you're an attorney, you are required by local rules to fill out a complete signature block, identify yourself, tell the court how to reach you. That's your basic probate of will petition. It's the first of many probate pleadings, at least arguably one of the most important pleadings, at least one of the 2 or 3 most important pleadings. That's all I've got for right now. Thank you for watching.